does one tackle the menace of an increasing number of heinous crimes being committed by juveniles? Is lowering the age and deterrent enough? Because we could see by the recent murder of Dr. Narang that this hasn't really worked. To discuss this with me, I have a panel of experts. We have Mr. Aman Hingorani, a Supreme Court lawyer who is also a counsel in the Nirbhaya case. I have Namita Bhandare, social commentator and columnist for the Hindustan Times. And Mr. B.K. Gupta, former police commissioner, who's also been the head of Tihar jail for 4 years. Mr. B.K. Gupta, can you there's a lot of grey area as to what exactly is a new law, apart from, say, lowering the age of the juvenile from 18 to 16. How is the 16-year-old, for instance, is he eligible for capital punishment? What decides?
No, I think just because of after Nirbhaya's case, there was a lot of furor, and so that led to this amendment. It is definitely a change in the entire perspective, because now a person above 16 years of age, he can be referred to a criminal court for purposes of trial as an adult, if he had that mental capacity and understanding to really, he knew the
and who decides this mental capacity and understanding?
It is the Juvenile Justice Board. Again, it is his inquiry and discretion that he will decide whether that child, because I would refer him as a juvenile is a child below 18 years of age. So, he will decide whether he had that mental capacity to understand the consequences of his act. And if he decides other way around, then this act is not applicable technically.
And is the person, the guilty person, can we give a capital punishment, death sentence to that person? Or?
I think that law, as far as my understanding, he cannot be given capital punishment. So, but definitely it is quite an improvement over the previous law.
Okay.
At least the children below 16 and 18, where maximum such kind of crimes were committed, they can be tried by a proper criminal court.
Okay. Dr. Hingorani, do you think the new law is an improvement over the old law?
I think it's half-baked. The old law as well as the new law, the entire juvenile justice law in this country misses the point. The idea of a juvenile law is that basically if a person who is not mature enough to know what he's doing cannot be punished because he didn't have the maturity. Conversely, if he knows, then he should be punished. We had, before this juvenile law came into being, before this international commitment, so the Beijing Convention, etc. Before that, we had the Indian Penal Code. It's a judicial function for the court to see the maturity of a child. Below 7 years, they can't be an offence. 7 to 12 years, it was a judicial function to see whether that person, that child, knew the nature and consequences of his actions. Now, what the JJ Act did was shut out the courts from the purview of dealing with juvenile, took away the power of the criminal court to even examine the maturity, and simply said we'll go on an age basis. 18 years and below, blanket immunity, no matter what you do, no matter how serious the offence is, no matter what the circumstances, even the victim is the child herself, the courts have no power. This person will be sent to a remand home for, not for prosecution, just for a child-friendly inquiry, and he'll be rehabilitated. And maximum period in the remand home is 3 years. Now, according to me, the new law basically reduces that from 18 to 16. So, somebody who commits a heinous offence, say 15-and-a-half-year-old boy or girl, that child will again be under the JJ Act.
Right.
So, the point is only this much, which according to me, the juvenile law in this country is based on the age, which is completely irrelevant as far as I am concerned. According to me, it's the mental maturity of that individual which has to be seen, not the age. And as you pointed out, who determines the mental capacity? The new law basically says it builds around a waiver provision which is there in the US, that the board can say, well, this child is mature enough, send him for criminal trial. That function is a judicial function. A board is not a court. And that is one of the biggest flaw in this particular law.
Okay. Namita, can I bring you into this? What is your, first of all, your feelings on the new amendments?
I think this amendment is a step backward. I'm not equivocating like Dr. Hingorani. I really think it's a step backward, and I'll tell you why. I think lawmaking for emotional reasons and under public pressure is the worst kind of lawmaking. what happened in December last year was that the juvenile in the Nirbhaya, or to use her proper name, Jyoti Singh, as her parents would like, he walked. He completed his 3 years and he was released. There was a huge public outcry, there was huge emotion. Parliament came under tremendous pressure and very quickly passed this law, and I think there were almost the left parties, NCP, DMK, I think were against it, but everybody else voted in favor of it. So I think lawmaking, because of what the public wants, or rather in this case what the mob wants, is not the best kind of lawmaking. Secondly, as Dr. Hingorani points out, there's, I think, a grave danger in allowing this kind of power to Juvenile Justice Board. Who decides, whether the 16 to 18-year-old who has been accused of committing a heinous crime, what is his mental maturity? A social worker and a magistrate? Who sets up the board? Who decides? What are the parameters? I think there are too many grey areas. My third objection to this law is that we've passed the law because, we love, we've suddenly become a very retributive society. We're not talking about reformation at all. Who is talking about conditions in jails? Who is talking about reforms in remand homes and in correctional homes where there is terrible abuse? We're not even considering all that. We talk about, and we quote statistics, but the fact of the matter is that juveniles actually commit 1.2% of all crimes. And according to a study by India Spend, which is a data journalism initiative, the repeat offenders amongst juveniles has actually come down. And in 2010, it was 12.1%, the repeat offenders. By 2014, it was 5.4%. So this whole fear that, oh my God, juveniles are on the rampage and they're committing terrible, heinous crimes, I fear is a little misleading. It's not that simple.
Mr. Gupta, you think this, are the amendments too harsh?
No, I don't think it is too harsh, because Juvenile Justice Act, it is complete as Juvenile Justice Care and Protection Act. Because we are party to that convention adopted by the General Assembly of the United Nations. So we can't just, too much amendment we cannot bring in, we cannot just remove all these provisions of the Act. This amendment is, I think, is quite okay, because now if Nirbhaya type of incident occurs and a juvenile is he's rated that he had that capacity to understand the consequences, he will definitely face the normal.
But instead of age, he made a good point about a 15-and-a-half-year-old committing a heinous crime. So should we look at the crime on the mental capacity rather than the chronological age?
No, then you can lower it to even 12, even at 12 or 14 years.
There are countries
they can have. But most of the countries, they have this 16 years benchmark. Okay. Most of the countries. So we have to be progressive. And we have to see the other side also. I have been a police officer. I can say that there is a psyche of a victim who has suffered who has faced the,
exactly.
So his psyche is totally different. But you have to see under what circumstances these children are brought up. That is a horrible circumstances under which they are being brought up. So their psyche is totally different. Okay. So they have to, but nothing is being done for the reformation and rehabilitation.
And that I'll go into a bit later.
But I do wish to add a couple of things here. First of all, the Beijing Convention, the United Nations Conventions do not require the member states to block out the judiciary as far as juveniles are concerned. Okay. They even contemplate trial. They may say have a separate trial, put them in jails which are separate from those of the adult prisoners. But the Beijing Convention, the international commitments nowhere say that a juvenile, a person below 18 can never be tried. And this whole thing about age, 15, 18, etc. is irrelevant. The studies in the US which says that the mental brain does not mature in some people till they're 21. So you might have 12
think of
to
a few
21.
names for that one.
So did you keep on, do we keep enhancing the age of responsibility? Do we keep decreasing the age? It has to be done on a case-to-case basis, not as a blanket immunity to everybody below a particular age.
Okay, that's a good point.
I would agree with that. And in fact, Mr. Gupta brings up a very interesting point. Are you now punishing people for being victims? He talks about some of the very hard and tough lives. A lot of these juvenile offenders are themselves victims of very terrible crimes and sexual abuse. So are we now going to penalize them for being victims? Because we're not talking about reform at all. We tend to take always, and I think this is the problem, and I think this is what Dr. Hingotani meant when he said it's a half-baked law, that we tend to take these half-baked measures. So we want to just lock them away.
I think he wanted more stringent punishment, no?
No, I don't. The Beijing Convention rules of capital punishment anyways.
Yeah.
I'm not, the last thing I would want to do is to hand over a child to a policeman.
Okay.
That's the last thing I would want to happen. But what I see is that many more often than not, the victims of these juveniles are themselves children. If there is a rape of a 3-year-old girl, what about her rights? So that's the reason, and if a person is raping, I'm sorry, they know what they're doing, regardless of the age. So according
And regardless
to me,
of the background, she's arguing in favor of the background.
Absolutely, and I'm saying that it is complex. I'm saying that we did not give this enough thought. I do not think that there was enough debate. Yes, there is rights of the victim. There are other complex issues. If you remember, there was an acid attack on a doctor about 12 months ago. The people who carried out the attack at the behest of a rebuffed paramour who was also a doctor were 2 juveniles. So he hired 2 juveniles to attack her with acid because he knew that they would get away lightly. So, so these are very complex questions. The other issue I wish to raise is the age of consent. So what we've done really over here, we've lowered the age from 18 to 16, and yet we've increased the age of consent from 16 to 18. 40% of all boys who had been accused of rape were actually in consensual relationships with minor girls.
you're right, the statutory rapes as we call them.
Yeah.
But then what do you do about situations where you have drug traffickers, for instance, who recruit people who are just below that age of 16, now early 18?
Yeah, that's the
So that's
the acid victim case. That's the same thing, that you recruit juveniles to do heinous crimes because you know they can get away.
There's a different. One is a person who's been subject to sexual abuse as a way, and that person is a victim, and they have been hardened because of this family background, socioeconomic strata. That is one kind of victim.
Okay.
Another is a person who's mature enough to know what he does, who willingly becomes part of a narcotics racket, but he is say 15-year-old. Law gives him immunity. Can it be a more ridiculous situation that take a situation where a person says commits an offense when he's 10-year-old. Maximum you can put him or her behind in the remand home, not punish, rehabilitate them for 3 years. Suppose the best of the experts say he or she is hardened. He or she will be commit a crime when he or she goes out. Law compels you to release that person. And you made there's actually no follow-up action. There's no proper remand homes, forget about follow-up action of rehabilitation. That person goes out, police is helpless, courts are helpless, and the person commits a crime at the age of say 13. Again goes scot-free.
What do you think will happen to a 16-year-old who comes out of Tihar jail, where he's meeting absolutely hardcore criminals?
No, don't keep them hardcore criminals. That's why I said throughout, you have separate cells. If a person is, our jail system is such that if you send people in for one crime, they come fitted for committing more crimes.
Absolutely. They'll come out with PhDs in crime, and these are young children you're going to lock up in
I
Tihar
agree.
jail.
But nobody is saying put them in hard jail, hardened criminals.
Let me ask Mr. someone who's handled Tihar jail to come in.
So I completely agree. The conditions in prisons are absolutely bad. Tihar is an exception, I can say, because this is in Delhi, a lot of funds are available. Just see the conditions
In prisons elsewhere.
elsewhere. It is pathetic.
And there's
And conditions of children home is much worse.
okay, I'm going to discuss
There is no
children's-
there is hardly anybody who is accountable for the conditions in children home, despite so much of scrutiny by the judiciary. They come down quite heavily on these children home, and there are a lot of external agencies working in Tihar jail kind of, there is an independent inspection, there are a lot of visits by the high court judges, and there is an inspection by the district sessions judge. So a lot of external scrutiny is there, but despite that, conditions are pretty bad.
Okay, we're going to discuss the conditions in the judicial remand homes, but we need to take a quick break. Welcome back to Cover Story. We are discussing the existing juvenile law and also what kind of deterrents can be put in place to prevent such heinous crimes being committed by young children. Now, Amita, I want to bring you in, before the break we were talking about the remand homes, where we send juveniles in the hope that they will be improved. But as Mr. Gupta pointed out, they actually worsen the situation, they're actually a den of crime themselves.
Absolutely, but are jails any better? I'm saying the solution, if you say remand homes are bad, the solution then is to reform those homes. The solution then is greater transparency, greater access perhaps to NGOs and to experts in the field to monitor those homes, and greater accountability from those who run those homes. The solution is not to put people in Tihar jail where conditions, as Mr. Gupta also said, are not great. And are you telling me that in Asia's most overcrowded jail, you're going to now make separate cells for juveniles, separate wards? How are you going to insulate these kids? I would call them kids.
Would you call them kids?
Well, depends again. I would say that if they are not mentally developed, they are kids. But I have a slightly different take on this.
Okay.
I go back to when my parents had filed the first PIL, untried business case, where people were in jail for years without trial, even while had they been given maximum, they've been tried, convicted, given maximum sentence, they were been released years ago. So if you're there for your articulous travel was the offence, you're there for 20 years. At that time, there were children being born and brought up in jail. There were children who had diseases. There were leprosy patients in jail. In remand homes, a 1982 case, Munna, where children were from remand homes applied to the jails for sexual gratification for the convicts, and Munna was a boy who could not sit because he was in so much pain. This was a condition which was in 1979, 80, 81.
Has it improved now?
We read reports about juveniles in remand homes going on strike, breaking the doors, running away. So, lack of implementation is the bane of this country. You can have excellent laws, you can have excellent speeches being made by all concerned, whether it's the courts or whether it's parliament. But on the ground reality, what happens, nothing moves in this country. So, there's a lack of implementation. So, while I completely agree whether it's choice or not between jail or remand homes, whether it's a jail or in separate cell or remand homes, it's utopian thinking or idealist situation, they'll be functioning properly.
What would be a deterrent to prevent some such people that if you commit a crime, whether you're 16, 18, forget the age?
I'm not a lawyer, Priya, but I would say that the whole idea of juvenile justice is not so much deterrent, but is reformation. The whole idea, why do we try children separately? Because the idea is that we can reform them. They're not yet formed, they don't have opinions. We can make them useful, we can rehabilitate them, we can make them useful citizens of society. They're not hardened criminals. So we're not really looking for deterrence, we're looking at reform, and I'm afraid we're not talking about that at all, because we're just happy to just lock them up or bring down the age, and everybody's happy and goes to bed and waves their candle or puts off the candle and goes to bed very happy, saying what a great thing we've done, we've brought down the age of justice, but you've achieved nothing.
Mr. Gupta, what would in your mind would be the adequate deterrent? Yes, we need to reform our homes. Beyond that,
I would not, whatever deterrence was supposed to be brought in, it has been brought in by this amendment. But you see the entire Juvenile Justice Act, which was enacted way back. The word is the care and protection of such children who are either street children, abandoned by the parents, they have no home, they have been sexually abused. So they are children in need of care and protection. That is the entire philosophy behind this act. We have to understand, this act was primarily aimed at protecting such children or those who are working in factories in contravention of labor laws. This act was basically designed to protect such children. So we have to see in totality, we have to see in totality how best we can provide deterrence also, which has been now adequately provided for in this new amended law. At least
but look at Dr. Narang's family, they may not agree that the deterrent has been adequate.
No, but now at least they can be tried as an adult, because if they are above 16, I am not aware what was their age, but above 16, at least if they are above 16, they can be tried as an adult, and I think they have a registered offence under culpable homicide provisions. So that provides for fairly good punishment. So, it is for the now Juvenile Justice Board to refer them to, because I think this is a fit case to refer them to a proper trial court, because they have come, it was an act which was done with lot of determination and premeditation. They have gone back, brought lot of people and then assaulted him. So, it is not that it is just done at the spur of moment.
To sum it up, do you think the new law looks after more the rights of the victim or the rights of the perpetrator?
Well, it's supposed to look after. It's supposed to look after, of course, the rights of the victims and, like one out, rehabilitate the persons who are guilty of that particular offence if they are not hardened enough. But the broader, real deeper issue is about the credibility and the accountability of the institutions of the state. You're talking about police NGO network. Police is suspect in this country. You're talking about deterrence. You have judgment. You're just, it's wishful thinking that a case finishes during your lifetime. So it's a deeper question about the character of the Indian state itself. Of course, there has to be implementation. The focus should be on reformation, but you just need to actually have a systemic reform across the board, which is again being very optimistic. But unless you do that, having the plenty of laws on paper,
correct, yeah,
that has to translate into something on the ground, and that doesn't happen in this country.
So as with all our things, I think the juvenile, you want to have the last word?
Yeah, I'm just saying, I often think, because, I'm a little ambivalent, as a mother, I often think, what would happen if I was the victim? What would happen if my daughters were the victim? And I would absolutely demand justice. Yeah. But I think as a society tells the world, the society is who we stand for. And very often how we treat the worst and the most depraved amongst us tells us who we are as a nation and who we are as a people. So an Ajmal Kasab gets a fair trial, an enemy of the state gets a fair trial and is then hung. And then gets, he gets his day in court. And I think that...
And his biryani in jail.
Well, so allegedly not. Okay. Because Mr. Nikam then said that he had kind of pulled a April Fool joke on the nation. But so I think sometimes you have to put aside and say that, okay, as a society, which way do we want to go? Do we want to look at this? Is like Dr. Hingurani says, do our systems work? I think we should be really focusing our energy on that rather than passing knee-jerk acts that may or may not stand the test of time.
Okay, on that note, we're going to end now. Thank you for watching this edition of Cover Story. We'll see you again, same time next week.